Hello, this is Matt on the Moon Lambo channel, and I've got an update on a story that I reported on yesterday. Things happen quickly. I tell you what, in the world of crypto in general, but my gosh, there's just been an incredible volley of legal documents filed by the SEC and Ripple and other attorneys not associated with either. It's been a lot to keep track of, frankly, but it's great too. It's all very fascinating stuff. And mostly good things are developing here. But here's a headline from Crypto Newsflash. Judge denies motion to intervene by XRP holders in Ripple vs. SEC case. And this isn't the only denial that I'll be covering in this particular hot jam on the Moon Lambo channel. But before going any further, I do want to be clear. I do not have a legal background of any kind. I am not offering legal advice. I do not have a financial background of any kind, and I am not offering financial advice, and so you should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys speaking about XRP and Ripple and crypto-related stories and topics and recording it all up on the YouTubes. Because frankly, I don't have anybody in my real life that would, on a daily basis, have any level of interest sufficient whatsoever to discuss these types of topics. Nobody in my real life cares enough. So I'm glad you do, because I am just as interested in these topics as you. It's a lot of fun to follow, especially when you got skin in the game too. But let's go ahead and dive in. Oh, by the way, I want to mention too, I've got, so this story has to do with action taken by Pro-XRP attorney John Deaton. I do have some fresh comments from him on this topic, so I'm going to quickly run through this piece here and explain what's going on, and then jump right into the new comments from John Deaton. Attorney John Deaton filed a motion to intervene in the case of Ripple Labs against the U.S. Securities and Exchange Commission on behalf of 6,000 XRP investors only the day before yesterday, March 14th. And the motion was now already denied yesterday within 1 day by Judge Annalisa Torres. Under Deaton's motion, Judge Torres states succinctly, and you can actually see it here. I think I had the actual document, didn't I? Probably somewhere around here. Well, maybe I thought I did. Oh, yeah, I do. It's right here. Yeah, this is it. So, so here's what I covered the other day. This is the actual document filed by John Deaton on behalf of the XRP holders and himself. And so it goes 3 pages, and then her response is just tagged on at the very end right here. And all it says is this: denied, in all capital letters. It's like, whoa, stop yelling at me. Denied. Denied without prejudice to renewal and a motion that complies with Rule 3A of the court's individual practices in civil cases. So ordered. And I said it like that because that was also in all capital letters. To express that her caps lock broke. That's what it was. The caps lock on the keyboard, it's broken, and so at inopportune times it just goes into yell mode, and other times it's just it's all little lowercase letters. It's just, I've had it happen to me. You know, we've all had to deal with that, right? First world problems, man. But anyway, neither Deaton nor Crypto Law had commented on Judge Torres's decision on Twitter at press time. In a tweet yesterday, however, Deaton was still combative, even if he himself admitted that the chances of the application being approved are rather low. And he said the following: "So when I filed the writ, I was very aware that our chances of having a judge order the SEC's chairman to amend the complaint to exclude today's XRP owned by holders with no connection to Ripple were very low. The experts and critics will claim that I'm wasting my time and I'm simply spinning my wheels going nowhere with the motion to intervene. They will say the same thing when a class action is filed. And in the end, maybe they will be correct and we lose this motion, and maybe later a class action is also dismissed on technical and legal grounds. If so, the critics and legal experts will get to tweet, 'I told you so.'" And I covered that thread, actually. It goes on longer than that, actually. But it still is worth, engaging in the fight. You don't know for sure what's going to happen, but that doesn't mean you curl up in a ball and die. And John Deaton is definitely bringing the fire, I would say. And then the piece continues. "It's important to note, however, that the application was denied without prejudice to renewal, which means John Deaton could resubmit the application. However, the deadline is set for March 17th, which means that the XRP army is unlikely to become part of the lawsuit, the SEC versus Ripple Labs." And look, I don't know what the likelihood of it is at this point, but that's not a reason, because it does look like John Deaton was moving forward with that. So anyway, as CNF reported, Deaton filed a motion to assert the rights of XRP holders in the Ripple vs. SEC case after the SEC filed a motion to dismiss Deaton's petition on March 5th, arguing that The U.S. District Court for the Southern District of New York is the only forum to determine XRP's status as a security or non-security. And so John Deaton said the following: if the Southern District of New York is the exclusive venue for decisions that have already proven to have a massive impact on XRP holders and are likely to set the course for the future of all cryptocurrencies in the United States, then that's where we must go. Indeed. And so John Deaton, he had a number of things to say, which I'm going to share with you right now. Let's start with this. There was this article from Cointelegraph titled "Judge Denies XRP Army a Seat at the Table in SEC vs. Ripple Case." And John Deaton wasn't really thrilled with this particular piece. They were covering what was happening with the motion, all this and that, everything that I've already covered on this channel. And he wrote the following: XRP holders, this article is 100% inaccurate and confusing. People, including lawyers and journalists, are misinterpreting the ruling and are citing inapplicable deadlines. For example, this article says, quote, according to court rules, the SEC is allowed 3 business days to respond to any such motion, but has requested an extension until March 22nd. It is unclear whether this extension, if granted, would also allow any legal team representing XRP token holders to file another motion to intervene. Barring an extension from the court, XRP investors may not have a seat at the table going forward in the SEC case against Ripple. So again, that whole little thing I just read there, that paragraph, that was from the article. And then John Deaton wrote, why would the SEC need an extension to answer a motion that has been already denied? The March 22 extension requested by the SEC is to respond to Ripple's 10-page pre-motion conference letter concerning their motion to compel production of documents. The extension has nothing to do with the motion to intervene. So clearly, I was just kind of chuckling the first time I read that. I was like, a bunch of C students writing crypto articles, man. Anyway, he writes, finally, the deadline to refile the motion to intervene is not midnight tonight. And he also said the following. And this was after the initial response, just this little one sentence here I wrote about denied without prejudice for, officially signed by Judge Annalisa Torres presiding over the SEC versus Ripple case. That one sentence there. After that, John Deaton wrote, XRP holders, what did I say about being knocked down and how we respond? It was being denied, quote, without prejudice, with the ability to refile in accordance with Judge Torres's local rules. This simply means it must be refiled as a letter motion. I'm on it. Please don't get discouraged. And so, to be clear, and I'm going to cover, he's got another tweet, but what he's saying right there is he filed something, this document, right? Okay. The judge denied it, but not because his points or rationale or anything is wrong or doesn't make sense or that she's opposed to it. It needs to be filed in a different way, and he said that indeed he is on it. Somebody named Kevin responded to that and wrote, any reason behind the denial by the judge? What would change if you refile providing the same case and evidence? It's not like she was in a bad mood this time and we'll catch her in a better one next time. Unless I'm missing something, I don't understand why she would deny it. And John responded, it wasn't denied based on the substance, i.e. case law and evidence. It was denied without prejudice because the judge wants it done in a different form. Articles I've written in a way, articles are written in a way to get people to click on it. I've seen an article that claimed we lost and the issue is over. Pure FUD. And so no, it is not over. Don't know for sure if this is gonna ultimately go through the way we want it to or not, but don't forget, attorney. I accidentally said that word that is not a word the other day too. Oh, that Moon Lambo, what a silly bitch. Anyway, so attorney Jeremy Hogan, in a recent video that he put out all up on the YouTubes, he said that his personal opinion is that he thinks that the judge will include John Deaton and XRP holders in this as interveners. And he went on to cite why, and I already covered it in a separate video as well, so I'm not going to go into it in this video, but he seemed very confident, actually. And so when I was reading these headlines initially, before I understood the substance or what had happened, at first I was just like, oh, that sounds like a negative headline, so it didn't happen. But that's actually not true. We're actually still waiting to find out what happens. It's just crypto media written by a bunch of C students that don't know what the hell they're talking about. And here we are. And so now you got John Deaton cleaning up the mess, and I'm trying to too. There we are. All right, but on to the next one now. Attorney Jesse Hines. This is interesting. I only mentioned this maybe like in one other video ever, maybe two, I don't know. But Jesse Hines, he's an attorney that's been publicly stating his perspective on everything having to do with the SEC versus Ripple case. He happens to have filed a Freedom of Information Act of his own. Now Ripple was filing one as well. They already did. It looks like nothing has come of it. But they Ripple filed a Freedom of Information Act requesting any documents that would explain how the SEC came to the conclusion that Ether and Bitcoin are not securities. Because it's very pertinent into just considering, okay, what's your rationale for XRP is perhaps completely different and nonsensical, and perhaps there's hypocrisy at play here. And so they filed a Freedom of Information Act. Well, Jesse Hines here filed a Freedom of Information Act, not seeking exactly the same information, so let me just quickly run through this here. Spoiler alert, it was denied, right? And even also, Jesse, though, here, you can see at the top he wrote, I knew the response I was going to get, but I tried anyway, with 2 laughy face emojis. So I appreciate giving it the old college try, as it were. Dear Mr. Hines, this letter is in response to your request, dated and received in this office on February 3rd, 2021, for access to any dissent or letters prepared by any commissioners against the filing of the lawsuit against Ripple Labs. You are further seeking access to any memorandum or materials prepared by the commissioners in past the rule to file the lawsuit. In your email communication of March 2nd, 2021, you agreed to the minimum of 2 hours of search time and the fees necessary to properly process your request, along with a date range of June 2020 to present. And keywords: XRP, Ripple, Ripple Labs, Ripple lawsuit, XRP security, XRP investment contract, to conduct a search for the records you seek. You also limited your request to search Commissioner Peirce's records, that's Hester Peirce, with any time left to search Commissioner Roisman's records as well. We have determined to withhold records in full pursuant to, and then they cite the code or whatever the hell, for the following reasons. Oh yes, goody. Can't wait to see what they are going to gobbledygook out here as a roadblock. Exemption 5 protects certain responsive information prepared in anticipation of litigation, which forms an integral part of the pre-decisional process and or contains advice given to the commission or senior staff by the commission's attorneys. This information is protected from release by the attorney work product, deliberative process, and or attorney-client privileges embodied in Exemption 5. Exemption 7A protects from disclosure records compiled for law enforcement purposes, the release of which could reasonably be expected to interfere with enforcement activities. Since Exemption 7A protects the records from disclosure, we have not determined if other exemptions apply. Therefore, we reserve the right to assert other exemptions when Exemption 7A no longer applies. And so basically the response that Jesse was expecting, it's just a question of what excuses was the SEC going to give. And now we know. What a good time, everybody. Yay! What a bunch of baby back bitches. Not my favorite. I'm going to go ahead and wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.